Now, welcome everyone. This is Robert Zarco. It's my pleasure and privilege to be before you today, addressing this issue of COVID-19 and the unprecedented loss of business that has been brought upon all the franchisees and small businesses in this country as a result of the onslaught of COVID-19, and more importantly, as a result of the civil authority mandates imposed by various local, state, municipal, and government and national governmental authorities. There's no question that what we are seeing now is unprecedented in this country, and it's having a substantial financial impact on franchisees and small businesses. Frankly, many of you find yourself in a financially desperate situation, and you're trying to think, what are my different sources of financial relief out there that I can rely upon or look to be able to go and get some kind of relief. One that people look to quickly are, landlords. Are the landlords able to provide rent relief? I'll talk about that a little later. Franchisors, can the franchisors provide royalty relief? And is the royalty relief an abatement, which means it's forgiven, or is it something that is deferred? Are the fees, other fees that the franchisors impose, can those be abated or deferred? How about remodels that are upcoming or other financial facilities, other financial requirements, perhaps arising out of facilities improvements that are required? Can those be delayed? Can the franchisor help us with low interest, short-term loans or longer-term loans to help us navigate through these treacherous waters? Perhaps we can have conversations with our vendors. Vendors are a very important and essential part of our business. We do not want to hurt the relationship with the vendors, but the reality is some invoices may have to be deferred. All of these have a domino effect in terms of when you make a request to one, what is the implication for them? For instance, if you request a landlord to abate or defer rent, what implication does that have in the landlord with regard to their mortgage payments or obligations to their financial institutions? What obligation does the landlord have to continue to maintain the premises? Are there common area maintenance charges that the landlord has to continue to carry out? These all present substantial difficulty to be able to play in this arena that has so many different moving parts. So in situations like this, where I find my clients who over the years have come up with situations where they do sustain a lot of business loss, many times due to no fault of theirs, I try to look at whether or not the franchisee or small business in fact has business interruption insurance. The most essential question to have answered is, do I, as a small business or franchisee, have business interruption insurance? If you know you have it, that's a good start. If you're not sure, ask your broker or ask an attorney to review your policy to determine whether you have it. It should be pretty clearly set out in the policy. But when I ask you to request your broker to assist you in determining whether you have the policy, not the coverage. The coverage is not something that I would leave up to the broker, and certainly I would not leave up to the insurance company. Do not play lawyer. It is very, very important that you understand these policies are extremely, extremely complex to navigate, as you will see as I go through this presentation. When the time comes to file a claim, you have to make sure you filed it within the appropriate time period. These policies have filing of claim deadlines. These deadlines must be met. Not all policies are created equal. Some policies have 30 days, some have 60 days, 90 days, 120 days, 180 days. In the exceptional case, you'll have a policy that says you can file a claim up to 365 days from the date of loss. However, what is the date of loss? The date of loss can be defined in many instances, in different ways. Different policies define them differently. These insurance policies are creatures of contract language, and the courts construe this contract language very narrowly, not broad, but very specifically. So for instance, is the date of loss here under circumstances where you have the onslaught of COVID-19, and then subsequently you have civil authority mandates that are imposed by local, state, or governmental authorities which of those two do you consider the date of loss? Any one of the two or both? It depends on the theories under which you're seeking to pursue your policy. What are the covered perils under your policy? You need to have a trained eye understand that. The policies only cover what you pay for. There are different policies that cover different things. The more expensive the policy, naturally, the more it's going to cover. It's a risk-reward analysis. There are all risk policies that provide insurance and cover all risks unless clearly and specifically excluded. Those are very, very good policies for us to work with. Now, there's a burden of proof, meaning who has to do what in order to determine whether there's going to be coverage. Initially, if there is a covered peril loss, it is the burden, it is the obligation of the person who is insured, you as the franchisee or the small business owner, to prove that you have sustained a business loss. I don't think that's that difficult to do. And you're going to claim, well, civil authority mandate came in and we were prevented and precluded from being physically present at our businesses. Or the argument of COVID-19, but we will talk about that being the argument. Then once the insured presents and proves that there is a covered peril loss of income, then the insurer will come back and say, yes, however, while there is a loss, there is an exclusion under the policy. And the policy sets forth different kinds of exclusions. For instance, if it's civil authority, this is civil authority mandate arise from a physical damage to the property. I'll get into that shortly. And is there another exclusion? Is there a viral existence or a communicable disease or a bacteria existence that is deemed an exclusion? Once that burden is satisfied by the insurance company, then the burden shifts again to the insured to establish that there are in fact exceptions under the policies to the exclusions, which in turn means you're back to being covered. These exceptions and exclusions and the way they work with each other is very interesting, but very complex. At times, these exceptions and exclusion, together with other language in these insurance policies, create ambiguity in terms of the interpretation. The courts say that all language in contracts have to be read in conjunction with other language. And if there is ambiguity, that ambiguity will be considered and interpreted against and construed against the drafter of the policy, which is the insurance company. Now, do you proceed to try to make a claim against the insurance company? A lot of people say, go ahead, let's go make a claim. Well, one of the most important things you need to do is undertake an early analysis of the policy to see whether or not the policy satisfies the covered peril requirement and whether or not there's sufficient policy coverage to justify the claim. In other words, does pursuing the claim make financial sense? Does the total coverage set forth in the policy apply to the matter at hand? In other words, sometimes you have a policy that has a $5 million total financial coverage. However, when you look at the policy carefully, you will see that there are sublimits under that specific coverage. For instance, it could say there's $5 million total coverage, but we will allocate $1 million for property coverage, $500,000 maximum for business personal property coverage, maybe $1 million for business interruption, and maybe there are other sub-criteria where there are caps. So when you look at the policy, say, oh, I have a $5 million coverage, you may not necessarily have that. Then, for instance, in our case here, where we're focusing on business interruption, when you look at the business interruption category that has, let's say, a $1 million cap, a $500,000 cap, are there sublimits within that category? For instance, if it's, say, to the extent that there is a business loss arising from the imposition of a civil authority mandate, that coverage will be $300,000. If it's law and ordinance, it may be another $400,000. If it's ingress or egress, it could be $500,000. If it's crisis management, it'll be $150,000. If it's loss of rental income, it could be $400,000. Whatever it is, you have to look to see whether the claims that you are pursuing have a sublimit that justifies the amount. Now, in those policies, many times there are what's called co-insurance provisions. And that means where the insurance company says, in the event you sustain damages as set forth under this policy, which we cover, the insurance company, the insurer, agrees to pay 80% of the damage, or 70% of the damage, or 90% of the damage. I've been looking at hundreds of policies, and I will tell you that there's a range of the insurer, insurance company, paying 90%, 80%, 70%. And in one case, I saw where the small business obligated themselves to pay 80% of the damage. So the insurance company was left with only paying 20. Of course, it was a much less expensive policy with a very small premium. Is there a deductible to these policies? You have to look at that. The insurer is only going to pay the balance of what the insured amount is, less the co-insurance amount, less the deductible. Then you have to determine at that point whether it's worth proceeding with the claim. But you need to make sure you have somebody who truly understands how to read this policy in order to be able to ascertain what is the precise amount that you're seeking to pursue. Let's talk about the brokers. The brokers play a very important role here in terms of understanding where you can obtain financial relief. And by that, I'm not saying that the broker is going to be your ally, because the broker may not be your ally. For instance, a lot of people call me and tell me, well, my broker says I have no coverage. Well, who is the broker? The broker doesn't necessarily have an incentive to make sure that the insurance company that they're working with pays out lots of money. The broker is not typically a lawyer who understands the detailed ins and outs of the policy, as well as the overwhelming amount of case law out there that creates all kinds of arguments on many of these issues that the broker would not be familiar with. You have to consider, first of all, who is the broker for the policy? Was it an independent broker? Who selected that independent broker? Did the franchisor tell you, go to this particular broker? That could create a situation that has to be looked into. And what was said to the broker at the time that the insurance policy was going to be purchased? Did you tell him what you wanted to be covered for? Did you tell him, I want to be covered for any and all business losses imaginable? In other words, you were speaking layman's language for you want an all risk policy. Were you concerned about the premium amount that was going to be charged? Or did you say, listen, whatever it costs, I want to make sure you understand that I need full extent of coverage? Who determined the price that was going to be charged? Did you say, no, I don't want to pay more? No, I want to pay less? Or was it your position, listen, I'm willing to pay a little more, but I want to be fully covered. In essence, I want an all-risk policy. The broker has a duty to disclose the extent and type of policy that the broker was selling to you. And they had a duty to explain to you exactly what the policy covered and did not cover. I would need to know what was told to you and what was not told to you. Let's talk about civil authority mandates. To close down due to a covered peril is the first step to look at. What are the covered causes of the loss or such peril under the civil authority mandates? What are the endorsements? What are the exclusions? Are there any limitations or exceptions to the exclusions? And how do each of these, working in conjunction with each other, impact your right to recover on such policy? But remember, there are exceptions to each and every one of these endorsements, exclusions, and limitations. So civil authority, you've all heard a lot about civil authority mandates, because that's something that is very much alive in America at this time. and it's possible that it's going to continue for several weeks, if in some jurisdictions, even several months. Let me explain to you what civil authority coverage is, and what it is intended to apply. Civil authority coverage is intended to apply to situations where access to an insured's property is prevented or prohibited by an order of civil authority issued as a result of physical damage caused by an insured peril to other property in the proximity to your property. If a civil authority shuts your particular property down with a described address, it's typically going to be because you had a fire, you had a flood, and the property is physically uninhabitable. Civil authority coverage requires for there to be a peril to other property in the proximity to your property. When that is applied, most of these policies, not all of them, again, these are creatures of contract. Every policy is different, even though there may be similarities. The insured must typically prove the loss of business income caused by an action of civil authority. Okay, we understand that. There's a mandate that says that businesses must be closed, restaurants, hotels, small businesses. Number two, the action of the civil authority must prohibit access to the described premises of the insured. I'm focusing on the word prohibit as opposed to the word suggest or request voluntary preclusion from visiting the property. And the courts are very much looking at the particular language. The third one, the action of the civil authority prohibiting access to the described premises must be caused by direct physical loss or damage to property other than at your premises. So what has become a very common response from insured brokers and companies that are denying coverage is simply there has been no physical loss to your damage or damage to your property, and no physical loss or damage to the property nearby. And that the definition of physical loss or physical damage is something I'm going to get to in a few moments, because the reality is the common interpretation that there has to be a damage to the physical structure, where the ceiling's going to fall down or a wall's going to fall down or things of that sort, are not so defined. And in fact, I'm going to tell you about a couple of cases briefly where the physical damage has gone beyond actual structural damage. And then the fourth requirement in order to collect under civil authority is that the loss or damage to property other than the described premises must be caused by or result from a covered cause of loss as set forth in the policy. So therefore, it's got to be based on what was the covered cause of the loss. There has to be a connection. Government advisories that urges precaution in or proactive closures, but does not explicitly prohibit access, may be an argument by the insurer that it does not trigger coverage. So expect that that will occur. So if the government permits drive-throughs or carryouts, then the insurer will argue that there is no prohibition to access. For instance, a lot of people are saying, I'm going to mitigate my damages. I need to bring in some income. Let me go ahead and operate my drive-through or my carryout. Under your particular policy, business interruption is going to be defined. And many policies indicate that the prohibition has to be to the property in its entirety, as opposed to a certain section. However, there's the duty to mitigate provisions in your policy, which requires that you do everything you can to reduce the amount of your loss, conflict with the other language in your policy that says that if you do it, your policy does not take effect. So now you have that catch-22 situation. Do I undertake delivery and drive-throughs to mitigate, but is that going to create an obstacle for me to pursue coverage? Catch-22, It depends on what the policy says, what the case law says, and most of the time on how good is your lawyer. The timing of the issuance of the government civil order is crucial. Case law indicates that if the civil order is issued in advance of the physical damage as a precautionary tool, most courts have found that there is no coverage because it's preventive in basis. But if after the actual threatened damage occurred is when the civil order mandate was imposed, then there is likely to be coverage subject to the 4 conditions that I enumerated earlier. There has to be a causal cause and effect link between property damage and a subsequently issued order. Some courts have found that physical damage to premises was not a prerequisite for the payment of benefits under business interruption policies. Some of your policies do not necessarily all have the physical damage condition requirement. Case by case, policy by policy, each one has to be able to be determined on its own. Courts are going to have to decide whether the presence or the threat of viral contamination, such as COVID-19, satisfies the direct physical loss requirement. In other words, is there in fact a physical damage or loss that can be argued as a result of the existence of COVID-19? Well, courts have found that even if there is not a physical structural damage, but in fact there is the loss of use of the property where it becomes uninhabitable or unusable, then that is a criteria that would satisfy that. There's a case out of New Jersey where ammonia was permeating the air of a described insured premise. And the court found that although there was no structural physical damage to the extent of brick and mortar and steel and rebar, there was ammonia in the air that rendered the property uninhabitable and unusable. And therefore, there was a determination that there was physical damage. There was a case in Colorado where gasoline vapors permeated an insured premise. And the court found that as a result of the existence of this substance in the air, it inhibited the use of the property. It substantially affected the value of the property. And more importantly, it impacted the ability for the insured to continue to function in the property and continue to run its business. So the property had lost its functional value. Some other courts indicate that even if it has these losses of use, value, and function, there are some courts out there that indicate that there still needs to be a requirement that there be a physical change in the physical structure of the property. Let's talk about this loss of use or this physical destruction or physical damage. For how long? Are we looking at a temporary suspension of obligations? Are we looking for coverage forever? Is this going to be something that now I can say I'm going to shut down my business and ask the insurance company to go ahead and write me a big check? There is a huge argument that's going to be made by these insurance companies is that even if there is coverage, there is something called a restoration period. What is the restoration period in order to be able to get the business to be able to be used, function, and reobtain its value? There's something called a temporary suspension versus a permanent suspension. Does 30, 60, or 90 days become a basis for termination of your underlying agreement with your landlord, your underlying agreement with the franchisee? So for how long is it that COVID-19 is going to persist? Is it going to evaporate? Is it going to evaporate in 6 months, 9 months? I don't know that we can be expecting that this thing is going to evaporate. I think it's going to be something that can be controlled. I'm no scientist, but I'll tell you, I'm learning a lot about it now, as part of my research on this area of law. But it's something that I hardly believe that the insurance company is going to say, sure, we'll cover you for the next 2 years as long as there any active COVID-19 patient out there we're going to provide coverage. That's just not going to happen. On the issue of physical damage, it was a Massachusetts case, believe it or not, just to show you how no case is too difficult. There's a Massachusetts case that said that there was an unpleasant odor in an insured business, and the court found that to be a physical damage. I can only imagine that being a litigator's haven to determine what does unpleasant mean, and at what level is there a meter that determines whether a cologne, a perfume, a gas, or something, like a sewage spillage is unpleasant. The point I'm trying to make here is that all courts look at things differently. Again, you need to look at the policy with regard to what is the restoration period. Those restoration periods cap the period of time or the time measured by the occurrence of the event which the insurance company feels it has to cover. In another case in Virginia, toxic gases from defective drywall, or like the Chinese drywall cases. In a lot of these cases, the courts found that toxic gases also deemed to be a physical damage. Now, in talking about the insurance aspect, you notice I did not talk about force majeure. And the reason I did not talk about force majeure, because that's not necessarily applicable in the insurance scenario, unless the insurer wants to argue at some point that the whole policy is not enforceable because of force majeure. That's not going to go very far with them. The force majeure clauses and the act of God clauses are contract creatures. These are provisions that are utilized as defenses to contractual performance. The courts define a force majeure clause as a contractual provision that allocates the risk between the parties to the contract if performance by one side becomes impossible or impracticable as a result of an event or effect that the parties could not have anticipated or controlled. However, it does not have to be completely unforeseeable to still allow for it to serve as an excuse for non-performance. In other words, you don't have to establish that Martians, are going to be landing on Earth or landed on Earth in order to be able to exercise force majeure. Hurricanes, there are things that are foreseeable. Floods, there are things that are foreseeable. Things of that nature are, in fact, force majeure. Act of God clause that are typically within force majeure is a natural phenomenon that are exceptional, inevitable, and irresistible, and the effects of which could not be prevented or avoided by the exercise of due care or foresight by the parties. I believe that Corona-19 is in fact going to be deemed an act of God. Now, COVID-19 is clearly an event outside of anyone's control. Well, some people may think that the Chinese government was controlling it, but that's for another day. So the reality is this: what is an out of control or a matter that's outside of control? Courts have found that if somebody who's a principal to a contract has a heart attack, that is a force majeure, and that excuses performance. If there's a flood, if there's a hurricane, for instance, sudden illnesses, fire, theft, acts of God and natural disasters, but not situations where a party can take action to protect themselves from these risks. Fear and uncertainty of something occurring does not excuse non-performance. If you're simply fearing COVID, or there's an uncertainty of it, or you fear that there's going to be a civil authority or uncertainty of it, does not excuse an early non-performance. You have to perform. However, that is an argument that I intend to use conversely against insurers, because the reality is the insurer will not be able to use that defense, and say, oh, there's an exclusion to the policy, and we don't cover viruses or communicable diseases. And I want to say why. It did not yet occur in our area. You're simply fearing it. It's simply an uncertainty. So you can see how I'm going to play, with that theory. Does the virus exist? Where does it exist? Is it an actual threat, or is it simply an existence or a fear? You have to determine how that's going to apply to their imposition of an exclusion. The communicable disease is an exception to the policy. There was a case in Hawaii. A force majeure clause did not excuse performance for economic inadvisability, even when the economic conditions are the product of a force majeure event. In that case, the court went ahead and differentiated between economic performance and other performance. For instance, if the business was losing money alone, and that was the only thing not connected to anything else, it was not deemed in that court for force majeure to apply. On the impossibility of performance. So is there an impossibility to perform? Well, if the civil mandate is now for a period of 3 months, you may have an impossibility to perform now, maybe not. Is there a permanent impossibility to performance? Did it so destroy your business during this time that your business can never be reestablished and rejuvenated? Arguments that can be made is, did the damage here cause the business to lose its customer base and its ability to be resurrected that it is deemed permanent, or is it simply temporary? Many courts find that monetary obligations, economic obligations, may not be excused. And one of these instances in which this principle is most important is on the issue of rent. And the rental obligations that you have, whether it be a reduction or rents not being paid, you have to look at your leases in terms of what is required, what is not required, and whether or not there is, if not an impossibility of performance, what's called a frustration of purpose. There's a lot of people don't understand the difference. In possibility of performance is whether something that makes it impossible for you not to do something. A bridge between you and your business was knocked down and it is impossible to get to the other side. That's an impossibility of performance. A frustration of purpose is did an event occur that frustrated the purpose for having ever entered into the contract. That's a more complicated analysis. Now, the interesting part about the imposition of some of these contractual defenses and exceptions and exclusions is there is that almighty obey all laws clause that exists in each of our franchise agreements, which say that the franchisee and the small businesses have an obligation to comply with all municipal ordinances, laws, governmental authority, impositions, and things of that sort. So when somebody says, the insurance company says, you know what? You voluntarily followed that governmental mandate. And you say, oh no, there's an obey all laws clause in my franchise agreement that requires me to do it. When the landlord says you closed your business voluntarily, or your franchisor said you shut down voluntarily, we suggested it or gave it to you as an option, but you did so voluntarily. You would say, no. I followed and obeyed all laws as you have required me to do. And I've had a lot of litigation over the significance of these obey all laws clauses and their impact. Let me give you some final points because I want to open up Q&A. There's a new wave, and I say wave because I think one ripple has started, but I foresee it coming down the pike, where franchisees are going to get sued by employees or even sued by customers if they fail to develop protocols in the manner in which the business is operated to shield you, the franchisee, small business owner, from lawsuits by such employees or consumers. For instance, Whether a franchisee or even a franchisor in their business or a landlord has cases filed against them, such as one where Walmart was sued and Walmart's landlord was sued for negligence from the wrongful death of an employee who died of COVID-19. And the allegations in the complaint are let me just read you a couple of them. For Walmart having failed to keep the premises safe and a healthy environment because the store knew that the nature of the business created a high-risk environment for infection and exposure to a high volume of people among employees and among customers. And can you imagine this? 2, that that Walmart failed to properly cleanse, sterilize, and otherwise keep the store in a pristine condition, free of unnecessary bacteria. 3, failed to implement and enforce social distancing requirements, where in fact there were signs that were missing, which now you've seen around many businesses that say we recognize, honor, and require social distancing to be enforced. Where the business owner failed to provide employees who maintained to work and continued to work at the business. They failed to provide these employees with masks, latex gloves, sterilizer soaps, Purells, antibacterials, or things of that sort. Number 4, failure to cease operations or to otherwise close the stores per the government mandates, or even before the government mandates were made, because you knew that other employees in your business were experiencing symptoms, not even actually diagnosed, but symptoms of COVID-19. The reality is there's fertile ground here for lots of disputes between franchisees, franchisors, landlords, the public, the employees, vendors, government, and insurance companies. This presentation could take 3 more hours. I have so much information, but I want to give everyone an opportunity to ask some questions. Enjoy your day. I've enjoyed speaking to you, and hopefully I've given you enough reason to become aware and created many questions in your mind. The most important thing here is that now you have a lot more questions. And when people tell you, oh, you're not covered, or oh, you're covered, make sure that you have someone who is adequately prepared and trained, a lawyer who specializes in this, to be able to give you the advice as to where you are, where you're not, and what the advice is. And make sure they're trial lawyers, because the trial lawyers are the ones that are most familiar with the manner in which the courts are interpreting and construing all of this language. So I'm open now for questions. And how do we do this, Misty?
Thank you, Robert. Can you hear me?
Yes, I can.
All right. Question number 1. What language should I say when I file my claim with my insurance company when I file a civil authority claim? My state has declared an executive order to close all my hotels in the county. Do I have a case?
Okay, that is a great question, because each claim has to be formulated based on the particular language in your contract, because all contracts are not created equal. If you say, I'm making a claim for business interruption because of COVID-19, and the insurance company responds and says, look at the policy, there's an exclusion for communicable diseases and viruses, you'll say, oh, okay, I'm done. You cannot do that. You need to have someone who has read the policy in detail, understands the complexities between the different provisions, and then you create the claim form to be consistent with the language in the policy. So whether or not you have a good case or not is impossible for me to discern at this point without looking at the individual policy. But don't simply file blanket notices of claims. You got to make sure. There's a lot of people saying, oh, it's because of COVID-19, and they're being outright rejected. You fall right into the hands of the insurance company. There's an art to how you file these claim forms.
All right, thank you. My insurance broker says that all insurance companies rewrote their exclusions after H1N1. to exclude viruses. Is that true per your understanding? I was told I did not have coverage due to this now standard exclusion.
I told you to contact your broker only for the purpose of asking him whether there is a section in your policy that deals with business interruption. Anything else is not within the purview of the knowledge of the broker. Yes, there was, in fact, after the last epidemic, there were exclusions drafted into some policies that set forth that communicable disease and viruses and pandemics should be excluded. The problem is as follows. A lot of times when these provisions and exclusions were added, there were other provisions in the policy that would give you coverage that were not taken out. And as a result, there's a conflict within the policies now with regard to whether or not those provisions actually override the prior provisions, because you have to read these contracts as a whole. And unless you have a person who understands how these different policies work with the other, you should not take the word of the insurance broker or of the insured. Whenever you get a letter from the insurance company that says denied, do you know how many cases are filed every year between insureds and insurers because the insurer wrongfully denies coverage? I can tell you that in the last 6 months, I've probably handled more than a dozen cases in which this dispute arose, not on COVID-19, but on other matters where the insurance company denied coverage. And then we ended up having to file a lawsuit, and we ultimately settled or won very favorably.
All right, thank you. I am not aware of anyone I know getting relief from their business interruption insurance regarding COVID-19. Are there some insurance companies who are approving them?
There are some companies that the nature and the manner in which their policies are written do not contain exclusions. Others have exclusions but do not require physical damage. There's others, the way that the exclusion is written is not clear enough, where they say, for instance, we exclude microorganisms. And the reality is that my understanding is COVID-19 is not one of those. So it all depends precisely on the language used in the exclusions and how that exclusion interplays with the exceptions to those exclusions, as well as how they interplay with the other language set forth in the remaining part of these very long, detailed, arduous, burdensome contracts.
All right. Subway has half a dozen gold standard insurers, which most franchisees use. Is it possible to scrub the policies and give advice on the validity of a claim, or does the policy differ by state?
It is, when you say scrub the policy, meaning review it to determine what is covered and is not covered among the different policies?
I believe so.
Yes, of course. Every policy can be reviewed, and we can give you an evaluation as to the strength of each one of these coverages.
Okay. We have a couple more.
One more. Remember also that not every single community has the same civil mandate in place. Not every state has the same imposition. So, there are differences in that regard. So you have to apply the policy to the particular facts of your particular situation.
Okay. How much will the fact that a state of emergency or national disaster zone was declared help in defending against lawsuits by customers or employees?
I think that is a big defense, a very big defense. It's not an absolute all in all. It all depends on how you as the business owner handled, dealt with, and confronted that mandate. How did you handle it? Were you reckless or were you diligent? It's all of a due diligence issue in that regard.
Okay.
It's very important that when you pursue an analysis of these insurance claims, that you find someone who's willing to take this matter on a contingency or results accomplished legal fee basis. If you're going to be paying someone by the hour to do this work, you're going to be paying a fortune. So make sure you seek out a law firm that is willing to and has the financial wherewithal to be able to support representing your interests on a contingency fee basis, or primarily a contingency fee basis.
Okay, thank you. A number of states are considering legislation which would force insurance companies to cover business interruption. Can you comment on this, and if you have any knowledge with respect to New York and New Jersey?
I have a lot to comment on this, and I'll tell you why. Not only have I spoken to various legislators and lobbyists, but also used common sense in my many years of experience as a lawyer to tell you that there's a fine line that's going to have to be drawn with in terms of what the government imposes on these insurance companies in terms of what they have to do and what they don't have to do. There are constitutional issues that are going to arise as to whether or not the government can impose contracts as written to be, in essence, rewritten. A lot of people think they're going to sit on the sideline and wait for the government to write them a check for the business loss that they have sustained, where you're going to go ahead and fill in the blank and say, I lost 500,000, I lost $1 million, and I want to be able to go ahead and get that money from the government. I will tell you the chances of that happening are less than me walking on water. And I'll tell you why. The government is not going to step into the shoes of the insurance company in terms of, responding to every one of these business interruption claims. What is going to happen, and this is my educated view of what is going to happen here with the government, is the government is going to let the insurance companies handle each one of these claims. There are going to be many policies that they're going to have to pay on. There are going to be other policies that they're not going to have to pay on. What the government's going to do is step in to create a fund to back up the insurance company's abilities to pay on the claims that the insurance company has an obligation to pay on, so that the insurance companies don't go belly up and that the insureds can get the money from the insurance company. It is not going to be, as I foresee it, again, I think it would be, as much as I'm obviously in favor of a small business, I myself own a restaurant, big restaurant, had to shut down, had another franchise I had to shut down, and my own law firm we're working here like in hazmat suits, except today I wore something different. But the reality is, we have an essential business taking care of all our clients that are in deep trouble, calling us constantly. And the reality is that in a situation like that, we're going to have to make a claim to our insurance company. And then the insurance company, once it is determined that we're entitled to some money, then the insurance company will go to that governmental fund to help pay for this. It is not going to be, I would be shocked if the government is going to overstep the insurance companies, step into their shoes, and be a direct conduit of funds from the government directly to the insurance company. Because the way the government is looking at this now, all of the stimulus package, a lot of the money being paid by the government now for stimulus, if you think about it, guys, it's another way of calling it business interruption insurance. When the government is giving you money for 8 weeks or 10 weeks to pay employees on payroll, the payroll of employees, and offset some of the rent, in essence, that is business interruption insurance provided by the government. So I think people need to be proactive as to how they deal with these insurance policies, and not sit and wait for you to all of a sudden get a check from the government because you wrote on a blank form that you lost $1 million without taking into account, are there exclusions? Are there exceptions? Are there subcategories? Is there coinsurance? Is there deductible? Have you paid your premium? How much did you pay? Is it an all-risk policy? If it's not an all-risk policy, the United States government is not capable of handling and administering that onslaught from every business income loss claim in this country.
Okay, I think that's a great place to end. We're getting a lot of questions about how to contact you and your firm.
Zarco Law, just look at zarcolaw.com on the internet. zarcolaw.com, or there's my website, and you'll have all the information. My email is rzarco, Z-A-R-C-O, R for Robert, rzarco at zarcolaw.com. Our phone number is 305-374-5418. We're here to help you. We are in very high demand, so please be patient when you call. We will call you back immediately, but we will work with you and just start putting all your policies together. And if you have not filed a claim yet, try to hold off until we speak to you, because I would like to be involved, or whoever your lawyers that you select, to be involved in the preparation of the claim.
Thank you so much, Robert. That was a fantastic explanation. And thank you to everyone who is on the call. We will be sending out a link to this webinar within 24 hours. And we'll be sure to include Mr. Zarco's contact information on that email. If you have any questions about CFA, you can email info@thecfainc.com.
And Misty, I want to thank you for having given the franchisees the ability to be exposed to this. There are a lot of misunderstanding and misconceptions floating around this country that are hurting a lot of people. And at least this information of a platform that you provided is really a great service that the CFA has provided. And that's one of the big reasons why I'm an active participant and so greatly support the CFA for everything that it does to help the franchisee associations and its memberships.
Thank you so much, Robert. And thank you for all you and your partners do for franchise.
My pleasure.
That will conclude our call. Thank you to everyone who participated, and please stay safe.
Thank you. Thank you, Misty. Thank you, Robert. And thank you to everybody who joined us this afternoon. As a reminder, a copy of this webinar will be emailed to all registrants within 24 hours, and that email will include Mr. Zarco's contact information. We wish you all a safe and happy rest of the week.
Stay safe.